Great. Hi, everyone. Welcome back. We are about to start session 2 of the KO Privacy Bootcamp. In this session, we'll be talking about your privacy policies, transparency, notice obligations, all of those fun things. My name is Erin Locker. I'm here with my colleague, Sahara Williams, and we'll go ahead and get started. So to get started here, I just wanted to take some time and talk about where we've come from and where we are now. Privacy policies have been something that we're all consistently focused on over the past few years. And a lot of the time, you know, the underlying reasons we even have these privacy policies on every single one of our websites in the first place is unclear. It's kind of become something that every website, we know every website has to have it, but we may not remember where it all started. So I think it's helpful to look at the history of the privacy notice requirement, and also keep in mind that everything we'll be talking about is still applicable, right? So all of these obligations that I'll be walking through are still in place, even though we have a lot of new privacy laws on the books this year. So 2013 was our first big year for privacy policies. CalAPA was passed, which required a privacy policy for websites and other online services. Pretty limited. We'll look at some of the limited requirements there. Obviously, 2018 was a huge year for privacy. We had GDPR come online, and that was probably the first big activity in the privacy world when everyone realized, okay, we have to actually tell people lots of information about what we're collecting, what we're doing with their data, how we're sharing it. The next big kind of landmark in the privacy world was in 2020 when the California Consumer Privacy Act first came online. Obviously, today we'll be talking a lot about the updates to that law from the CPRA. That was another big milestone. And now moving forward, as more and more states come online with their own privacy laws, as a federal law is being considered, I think the expectation should be that there's going to be a consistent need to constantly be paying attention to these laws, reviewing privacy notices, doing annual updates, paying attention to the evolving landscape, because there's a lot of requirements around what businesses have to disclose to consumers, to business partners, to anyone visiting the website that we're operating. So just to look back, I mentioned that CalAPA started off in 2013. Again, really simple requirements. Back in the day, we used to just have to disclose the categories of personal information that were collected, how it's shared and used, and the only data subject rights were optional. So how to you could tell people in your privacy policy how they can review and request changes to their PII, but again, not a requirement. Things have drastically changed since then. As a lot of you are probably have at least heard of GDPR, but back in May 2018, a big overhaul came to privacy policies, in addition to just telling people how their information is collected, used, and disclosed. GDPR also imposed a lot of additional transparency obligations. So under GDPR, we have to explain our purpose for processing data. We have to identify a specific legal basis that we're relying on for processing that data. We have to explain all of the data subjects' rights. So GDPR, like all of the new privacy laws coming online in the US, mandated lots of data subject rights. And yeah, just a lot of different disclosures were required that weren't previously in scope. And of course, with GDPR, a lot of US businesses got pulled into that. And then more evolution in January 2020, when the CCPA came online, a lot of those GDPR-esque privacy obligations came home to the United States. In addition to additional data subject rights in the United States, the CCPA also imposed a lot of additional disclosure requirements about how personal information is used, the specific commercial and business purposes why personal information is used, whether we are selling personal information. So lots of additional disclosures. And now, as 2023 is on the horizon, all of the state privacy laws that we've been discussing, Colorado, Connecticut, Utah, the update in California and Virginia, all of these are going to have much expanded privacy notice requirements. Some are similar, some are very different depending on state. But four of kind of the key changes that we need to be paying attention to as we're updating our privacy notices are: one, enhanced disclosure obligations. So generally across the board, it's time to get a little bit more specific about what data we're collecting and how we're using it and how we're sharing it. So in the past, it's been appropriate to make some generalizations, for example, about what third parties we're sharing data with. As the new laws come online, we're going to have to get a lot more specific about that, and we'll get into the specifics in detail in this presentation. Another big headline point is individual data rights. In the first presentation, there's a brief overview of those. We'll get into those in detail in the third presentation. But in general, the privacy notices will now need to go into detail about all of the rights that are offered to consumers and other individuals under these new laws. Another big change to be aware of is the offline delivery of privacy notices. Right back in 2013, when we were looking at just CalAFA, we were focused on online websites, online services. Privacy laws are going offline. So paying attention to where we're collecting data in all contexts in our business, whether or not it's just on the internet. And then finally, disclosures that are related to selling data, sharing data, targeted advertising, and then of course financial incentives, and we'll dig into all of that during this presentation. Now Sahara will get into more of the specifics about the components of a compliant privacy notice.
Thank you, Erin. Yes, so let's get into what we're actually including in our privacy notices. There are, we're going to talk about the four main sections that we want to put in our privacy notice, and then we're going to talk about the California specific requirements and how those differ from the other requirements, because as you now know and have heard throughout the presentation so far, California is always doing something extra. So we're going to start with the categories of personal information collected. Then we're going to talk about the use and or purpose of that, of collecting that and processing that information. We're going to talk about sharing or disclosing the personal information, and then consumer rights and how consumers exercise their rights. And then the California specific requirements are, we'll talk about at the end, related to some additional requirements for collection of data, retention, and financial incentives. So categories of personal information collected. We must disclose the categories of personal information that is collected or processed. And those categories you can tailor those towards your business and what you're trying to achieve, what information you're collecting in general. Some examples are identifiers, name, contact information, your commercial or employment information, health information. Network activity is a big one that generally all businesses are collecting. So we want to get that collected. In California, the extra step is that they have enumerated categories and they want the data tied back to the categories that are in the statute. And so we want to make sure that we're covering California when we're working globally, when we're working nationally, and that we're tying the information that we're collecting back to the California CCPA statute to be compliant with California. In addition to the personal information category, the subcategory of personal information that the CCPA is taking into account is sensitive personal information, and that has subcategories as well. And that generally can relate to financial information, how do you get into, that allows you to get into an account, also your racial or ethnic information, sex life, and topics like that, that we want to make sure that we're categorizing to that specific list as well. Addition-
Oh, sorry.
Additionally, in California, we want to state, for California, we want to state the sources of information where we're collecting those information. And there are generally 2 to 3 categories of sources. One is always going to be your consumer, the direct from consumer, and that's when they sign up for an account or sign up for your newsletter. They are directly giving information. Indirectly through cookies, that the analytics that we may be collecting, what web pages they came from and what's in their cart, things like that. And then sometimes there's also the third party information that we get from third parties.
Real quick, I thought something that is interesting that you mentioned network activity. I think I still see this on a daily basis in privacy policies is when people are disclosing information that they collect through analytics cookies or through pixels on their site. They sometimes are saying, we're collecting anonymized or de-identified data or usage data that doesn't constitute personal information. And I think it's really good to call that out here because, especially for businesses that haven't had to comply with the GDPR in the past, now that all of these new privacy laws are coming online in the US that expand the definition of personal data, it's going to be important to check privacy policies to make sure we're encompassing the new definition of personal data, right? So all those things, IP address, right? Advertising ID, device ID, all these things that in the past, a lot of US companies may have considered to be anonymous data or just usage data and not falling within the coverage of these laws and the privacy policy. The disclosures now are going to have to cover all of those things if we're not already kind of looking at them before because of GDPR. So I think it's a really good point to call out that network activity is probably something that if you haven't looked at GDPR before, that's probably something in your privacy policy you'll want to revisit.
Absolutely. Any information that you bring in that can be tied to an individual consumer or household or device is personal information. You may later de-identify that information, but if it is tied to an individual, and while it is tied to an individual, it is personal information. So the next big bucket, we talked about collection. Now that we've collected the data, we need to tell consumers how we're using it. And the use and purpose are a little bit interchangeable in terms of just explaining what you're going to do with that data. Why are you collecting the data? And what purpose is going to come out of that data? In California, there must be, the disclosure must be tied to a specific business purpose, which is a defined term in the CCPA, or a commercial purpose, which is another defined term in the CCPA. And in general, without reading the lengthy list of ways you can meet the business purpose description, I'll just say to think of it as an operational purpose. You have the service that your consumer is purchasing from you, and then you have all the things that your business needs to do to operate. The audit that you may need to do on your system, the security that you may need to do on your network, how you develop your product and continue to improve on your technology. Those type of uses that are critical to the business, but not necessarily a direct service to the consumer, those would be your business purposes. Your commercial purposes are really, as the name says, is the commercial transactions, the economic interest of the business, that how you're generating your money. And so you want to make sure that the collection, when we disclose the collection, we're disclosing how we're using that. And in California, we want to tie that to the specific business or commercial purpose. And another key point is that we want that disclosure to be meaningful. So we don't, as Erin stated, the pressure is on in our new laws to not just be broad in our statements and put something out that's kind of generic, but have something that's meaningful to consumers. They're the audience in writing these privacy policies, and we want to make sure that we're providing them a service through our notice. So once we collect our information, we have our use and purpose. We're more than likely going to share that with someone, with our vendors and sub-processors, with third parties for advertising purposes, with just our business partners, just to be able to get the product out, the shipping information or the payment processing information. There are a lot of different entities that we end up sharing data with. And we want to disclose not just the categories of personal data that we are sharing, but also the categories of third parties that are receiving that data. Additionally, targeted advertising has been a key focus for new laws, and we want to make sure, and they're asking businesses to disclose to consumers whether they're doing targeted advertising, whether they're selling information for that monetary or other valuable purpose, whether they're doing tracking, and in some cases, whether they're doing profiling as well. In California, we again have some specific requirements. We want to again tie that disclosure of sharing disclosure to specific business or commercial purposes. We want to do it in a way that is meaningful to the consumer. And then California has two statements that they ask businesses to make. One is related to whether or not they have actual knowledge of selling or sharing data of children under 16. It's a hint, the answer should be no. And then also what sensitive information is being collected, and whether that sensitive information is being utilized for a purpose beyond that which is simply necessary for the service you're providing, for the product you're selling to the consumer. There's an additional requirement under California law for large businesses that are collecting. That's a dollar sign there. It should not be there. I apologize. But it's supposed to be 10 million consumers or devices that you're collecting personal information on. So not the dollar sign, just 10 million people that you're collecting information on, in which case you also need to disclose the statistics surrounding your consumer request to exercise their rights. And those, again, as Erin said, are going to be discussed in more detail in presentation 3.
Yeah, one thing I think is worth mentioning here. So back in the day when the CCPA came online, I don't know if any of you went through the process of doing the initial privacy policy update for the CCPA, but the approach that a lot of companies took was to have this big chart in the privacy policy that said, here's the information collected, and then by category, this is what we're using that personal information for. This is who we're sharing that category of personal information with. So very detailed disclosures about like network activity, for example. We are sharing network activity with ABCDE. We are sharing financial information with ABCDE. The reason that a lot of companies did that in the beginning, because that was an original requirement under the California AG's first round of rulemaking to the CCPA, that eventually came out. So a lot of businesses actually simplified their notices and their privacy policies because we are no longer required to have such specific disclosures, right? It could be a general, we disclose all of the personal information categories we've listed with this list of third parties. Well, it's that. The current CPPA regulations are once again requiring that level of specificity, so it's going to be really important for businesses to it's a data mapping exercise essentially. Instead of just saying, you know, here's the personal information we collect, here's who we disclose it to, it's going to be here's one category of personal information we collect, and just that category, this is who we disclose it to. So the level of specificity that's required for privacy policies is very specific, and that's why data mapping, data inventories, knowing exactly what your data flows are within the business are going to become even more important, because the requirements that the regulators will be looking for are going to be heightened from what we're currently operating under.
So the next category is our consumer rights. We've collected the data, we've disclosed how we use the data, we've disclosed how we shared the data, and now our privacy laws are adding consumer rights, and we need to tell the consumer what their rights are, because often they don't know, because they're not reading through all the statutes to understand. So the laws that are coming out are requiring the businesses through their privacy notices to tell consumers what rights they have to exercise. And how you exercise those rights is of course important. What is the process that you need to follow? We'll talk about the verification process. Verifiable consumer request is a word that you will hear often in understanding how these requests are coming in from consumers. And we want to explain that process, explain the appeal if it is denied, because there are certain circumstances in which you can deny a consumer request to exercise their rights. And in California, they want the additional requirements of identifying the verification process and explaining that process to consumers. California also has opt-out requirements for the sharing or selling of data, and also opt-out for in order to limit the uses of sensitive personal information to just what is necessary for the sale of the sale of the goods or the services. And those all must be disclosed under California's statute. California also allows an agent to act on behalf of the consumer. We must explain that to the consumer. And then they have this other really unique caveat, which is that however easy you're making it on yourself to collect the information, they want you to make it that easy on the consumer to exercise their rights or opt out. So sometimes you may see a business that they have you sign a privacy policy at the time you enter the business, and it says we're collecting this amount of data. And if you don't want us to, you have to write a letter to some address somewhere else. So you might have to go to a website to figure out what the address is. Well, that is making it more difficult on the consumer to exercise their rights to opt out than you have made it on yourself as a business to collect that information. And what the law is really saying is those things should kind of match. There are circumstances, most commonly with analytics, where a third party is actually collecting data for what we would term as the controller or the main business. And so data analytics companies are collecting their own data, and they have control over that data. Those data under the CCPA now, you will have to list what those companies are or what they're doing. So you might see now the Google Analytics website privacy policy embedded into a business's privacy policy, so that that consumer understands not only do I have to understand the privacy that this business that I'm working with, their policy, but there's this additional policy from Google, and here's the link that I can go to get more information on that. And that also applies to offline businesses as well, offline collections as well. California does have, they have a non-discrimination clause, but they also have a financial incentive clause. So you can't discriminate against people that exercise their rights or opt out of selling or sharing, but you can offer financial incentive, and there are a lot of disclosures around the financial incentive, and you have to give that information either in a separate notice or as part of your privacy notice. I'm not going to go too far into the financial incentive because Erin's going to talk about that in detail in just a moment. The last thing I want to talk about as it relates to the privacy policy and California's specific requirements is the data retention. And you want to disclose the length of time that you're retaining all your personal information. If you can't say a specific length of time, you need to say the criteria by which you are determining that time, or that you will determine that time in the future. And in all cases, that retention period needs to be limited to what is reasonably necessary for the purpose that you disclose to the consumer.
Yeah, and if you're familiar with, if you're compliant with GDPR, then you should already have some of that retention language in your privacy notice. And one other point I think that Sahara brought up that I think is great is the requirement to disclose the names of third parties with whom you're sharing data. This is part of this draft regulations out of California. As you can imagine, actually having to disclose the names of every third party that's collecting data on your website, every third party vendor you have, I mean, you can imagine it could get quite mind-bending to try to do that. That's something that's in the draft regulations. We'll see if it actually comes through in the final regulations, but that's going to be a really, really big challenge when updating your privacy policies, because it's a challenge. It's another data mapping exercise, right? Where is all of this data actually going? And it can be quite a bit of parties. So now we're going to talk a little bit specifically about the notice of financial incentive. So this is something that's been around before, right? So the notice of financial incentive was already a requirement under CCPA. It's getting a bit of a revamp with the new California regulations, but one reason I wanted to talk about it today is because this has been a regulatory enforcement priority with the California AG. They've released examples of enforcement actions that they've, or notices that they've provided to businesses, and what some of those businesses have done to comply with this. So basically, the notice of a financial incentive is an additional notice requirement under the CCPA. So you've got the notice of privacy practices, which Sahara just talked through. The notice of financial incentive is required when the company is providing a program, benefit, or other offering for the collection, retention, sale, or sharing of personal information, and then offering a difference in price or services because of the collection of that personal information. So common examples we see are loyalty programs. I have my King Soopers card, I'm providing my personal information to King Soopers, and I'm getting coupons in return. Product discounts, different service tiers. I mean, I see a lot. Enter your personal information and download our white paper. Give us, your email address, and we'll give you access to this really cool new study that we did. And then freebies. Actually, please don't laugh, I am not a designer, but I did design these examples of financial incentives. This is why I'm a lawyer and not in digital marketing. But these are some examples of things that I see all the time on the internet. So, hey, welcome to our website, sign up, give us your email address, and you'll get 15% off. And then, oh, you don't want to, no thanks, you don't want 15% off, bye. So that's a great example of a notice of financial incentive. And also, while we're here, the regulations out of California have already highlighted that the no thanks, I don't want 15% off can also be a little bit manipulative to avoid those types of statements, even if you are providing a financial incentive. Another one, get paid to take surveys, click here, give us your personal information and we'll give you a Starbucks gift card. So these are examples of when you're collecting personal information for a price or service difference, a discount, some type of benefit to the consumer. So the reason we have the notice of financial incentive requirement is that we have to provide the material terms of what that financial incentive is, so that the consumer can make an informed decision, right? Because whenever you're offering any type of financial incentive, the consumer has to opt into that. So they can't just be automatically added to a loyalty program, for example, right? I can't walk into King Soopers and automatically be pulled into their loyalty program just for checking out in California. There's an opt-in requirement. And that notice has to be made readily available before the person opts in. So the things that we need to include in our notice of financial incentive to make it compliant is a succinct summary of what the financial incentive is. For example, Aaron, you give us your favorite Triscuits to buy, and we will give you a discount, a couple dollars off every once in a while, because we want to know that you like Triscuits, because we might use that for marketing purposes. A description of the material terms, the categories of personal information that are implicated, and also the value of the consumer's data. I think that's a key piece, is part of providing these notices of financial incentive is calculating out what is the value of this person's personal data to the business. So for example, in that example of the give us your email address and you get 15% off your purchase. What is the value of me providing my email address and signing up for the marketing list, right? There's some tangible benefit to the business from me actually becoming a subscriber into the marketing list. So one thing that this financial incentive notice requirement is obligating businesses to do is to actually calculate out what is that value to the business. The notice also needs to explain how the consumer can opt in. We also have to disclose the consumer's right to withdraw from the financial incentive at any time. I need to be able to get out of the loyalty program. I need to be able to unsubscribe from the service. And then finally, an explanation of how the financial incentive is reasonably related to the value of that consumer's data that we calculated. So if I am operating my e-commerce store and I take in, I want to do a 15% off campaign. Okay, so I've calculated out that Sahara's email is worth about $5 to me, just based on, the fact that she's going to be a subscriber. This is the rate at which I think she might buy products for my business because she's a subscriber. Now I need to show, okay, well, that value of her data to me needs to be reasonably related to the financial incentive I'm providing, that 15% off that I'm going to give her for purchasing shoes from my store. So all of these things need to be included, and this is something that is, I would say it's rare to see actual dollar figures listed, and kind of if you go out and you read notices of financial incentives that are on the web, there's a lot of different approaches that businesses take. So this is something I think we know that it's an enforcement priority in California, and we should definitely be looking at all of the kind of programs that we have. We're reflecting consumers' data and determining, is that a financial incentive and do we need to make a notice? So just a few examples from the recent enforcement sweep in California. I thought that these were great because it kind of, the AG gave us an idea of some of the things that they're seeing in the wild, wild west, and what I think there's a lot of lessons learned that we can take in here. So the first thing to note is just if you're operating a brick and mortar store, if you have physical locations, and this applies to privacy notices too, right? The notice of financial incentive needs to be presented at or before the point of the person opting in to the financial incentive program. So one of the examples the AG gave was that one company that received a notice of violation under the CCPA, they resolved the issues by posting the financial notice at their cash registers in their store. I don't know how they did this probably through a QR code. It's a really common way that businesses will handle the offline notice requirement. Another item that the AG called out was the requirement to link directly to the notice of financial incentive from the location where individuals opt in. So one way I've seen sometimes I'll see these financial incentives posted on the web, and then there will just be a link to the privacy policy underneath the financial incentive. So, right, sign up for my mailing list, get 15% off, here's our privacy policy. Well, the AG has said in these enforcement actions, that's not enough. You need to have also link the notice of financial incentive, and that link shouldn't just go to the privacy policy. It should actually go to the exact space in the privacy policy where the financial incentive information is disclosed. So really specific requirements about how we need to present this information to consumers. Another item that the AG called out was the lack of an opt-in to a financial incentive program. We talked about that a little bit, but just making sure that there's an express opt-in consent to the financial program. It shouldn't be, right, a pre-ticked box or a a way of gathering consent that doesn't require an affirmative action from the consumer. Yeah, the classic example is have that unticked box there. If you're signing up, if I'm checking out at the grocery store, I shouldn't automatically be pulled into the loyalty program, right? I need to be ticking that unticked box to be added to the loyalty program. And then finally, the other item that the AG called out was just the lack of information provided in existing financial incentive notices. It's just important to kind of go through the process and hit each of those points that the business is required to provide before providing the notice.
Okay, before we move on, I'm going to give the code for the distance learning for lawyers CLEs. The code is notice requirement, and you can email that code to me at swilliams@kofirm.com, swilliams@kofirm.com for your attendance requirements. That is for distance learning if you're not in Colorado, not a Colorado attorney, and need the code for your distance credit. So I'm going to talk now briefly about delivery and formatting requirements for your privacy policy. What is key again is that the notices are providing a service to consumers, and we want to have a document that is beneficial to consumers. It should be provided at the time of collection for online collection. It should be clear and conspicuously posted on websites. There should be a link that says privacy so consumers understand, where to find the privacy policy. It should be in the same font and size and coloring as other links that are on your site. So you don't want to make the legal requirements much smaller than your other requirements. And then for mobile applications, you also need to have your privacy policy tied to that platform. You want to have it through your settings, to the settings menu where it can be easily found on the landing page. And if you're downloading that from a website, then you should also have it where you're downloading it from so people can select and understand at that time of collection. As we stated here today, privacy now is not just about collecting online. It's your general privacy practices and policies, whether you're collecting that information on or offline. And so for offline collection, you still need to provide that notice to consumers. That notice should be presented at or before the point of collection. It should again be clear and conspicuous. If you're posting it like a sign, then the consumer has to be able to see it on site. You cannot rely on an online policy that you have not shared with the consumer that is in the room. So you want to be able to provide that notice in writing, or you can have a tablet, or you can share the link to get to that notice so that consumers will actually have the notice at the point of collection. You can also give the privacy policy orally, over the phone, or in person. For formatting, we want to have a policy that is reasonably accessible, clear, and there's that word again, meaningful. So under California's CCPA, there has been a longstanding requirement that there be some accessibility around your privacy policy, depending on what type of device you're using. Can people expand it? What type of options there are for functionality for persons with disabilities? And those requirements are found at the Web Content Accessibility Guidelines, and it is version 2.1 that is current. You want to provide languages, the languages that you use in your business. You should also provide your privacy policy in those languages. If you're targeting people in different areas and different contexts, then you want to be able to reach those consumers. You should also use policies that do not create the deep linking effect, where you have links that don't go to the sections or the portions of the policies that you're actually referring to. Your policies should be easy to read. They should be clear to the consumer, and use straightforward, plain language, as simple language as possible. And again, the meaningful word that we have repeated here several times today. Some formatting options are to use section headers, use your fonts, bold, different font sizes as you go from heading to subheading to the content, indents, underlines, italics. You can also create a table of content that links to specific sections to make it easier for a consumer to navigate a longer document. And our final segment for this session is a regulatory and litigation update, which Erin will give.
All right. So Chris already spoke about this a bit in our first session, but I'm going to go into a little bit more detail about the recent enforcement action against Sephora. Again, this was a big deal. This is the first CCPA enforcement action on the books, first thing we're seeing from the AG in detail. So the AG has given us some anonymized kind of pointers about enforcement that they're doing with companies that they just submitted a notice to. The Sephora action was the first actual enforcement action that we received. So we have the complaint, we have all of the requirements that the AG imposed on Sephora. And first, I just want to walk through kind of the things that the AG alleged against Sephora. So these are the things that they found by going to the Sephora site, that the company was not up to speed with the CCPA. The first item, and again, I'm kind of repeating a bit of what Chris talked about in the first session, is that Sephora failed to disclose their sales of personal information. This is going to be a big piece for all privacy policy updates this year, is to go and really look carefully at the sale disclosures we're making. Essentially, the AG alleged that Sephora failed to disclose the sale of personal information through its use of advertising and analytics collection on its website. And that was kind of the key headline piece of the enforcement action. So when all of you are going out and you're updating your privacy policies, it's really important to make sure that you're looking at all types of data sharing that will be happening under the new and updated laws. In addition to sales, right, we also have the sharing slash targeted advertising opt-outs. So a lot of that will get caught up in the review of those pieces, but it's really important to disclose which information we are sharing. The second was that Sephora failed to have a do not sell my personal information link. Obviously, that's the crucial part. Anytime you are selling data, you're required to provide the opt-out. And then the third piece that the AG really focused on was the global privacy control. Sephora was failing to honor universal requests to opt out of sales of personal information. So often the way this comes through is when someone's browsing on a privacy browser or something like Brave, there's a signal that's being broadcast as they go out to each and every single website that they visit. The California AG has been talking about this a lot lately. This comes up a lot in their guidance, but also the Sephora enforcement action really focused on the inability or the lack of Sephora's basically alleging that Sephora didn't comply with this global privacy control. And really the only way to do that is to use a consent management platform, to use technology to actually read that signal as it's coming onto the website. So I think a key takeaway from this action is to think about, okay, am I using a consent management platform on my website to accept and receive opt-out requests, and is it compliant with GPC? That's a key piece that the AG was focused on with Sephora. So in addition to a monetary penalty of $1.2 million, there's also some injunctive requirements in the enforcement action in the settlement. Sephora agreed that it would disclose its sales and its privacy policy, that it would honor the GPC request, and that it would amend its vendor agreement. So I think something that's really important to note here about this requirement is, yes, Sephora didn't disclose sales in its privacy policy. It didn't have the right sale opt-out disclosures in its privacy policy. One of the things that the AG focused on in the opinion is that one of the things that made all of these disclosures sales, right, is that Sephora didn't have the right contract language in its privacy or in its agreements with these third parties. So just keeping that in mind, we'll go into contracts in the fourth session, but just keeping that in mind that, you know, that is kind of quote unquote safe harbor from sales, is if you have the vendor language in your contract, the AG will look at it. That's a key piece of determining whether or not the disclosure of data you're making is actually a sale or not. Yeah, quick hits, lessons learned, pay attention to the advertising services you're using, honor GPC requests, and then update contracts for CCPA and then the upcoming CPRA for privacy laws. Another interesting one that I wanted to touch on is there's a class action against TikTok that just came out with a $92 million settlement. It's being appealed, but I think there's some great takeaways from this this settlement. I think first, we haven't really talked about biometric information today. That's something that's been the Illinois Biometric Information Privacy Act. That's something that's been around for a while. It's always important to notice when you're collecting and receiving biometric information. But this was an important I think settlement, and the injunctive terms are important because it highlights the importance of disclosing when you're collecting biometric information, getting consent, clear disclosures about geolocation data, and especially clear disclosures about data that may not be apparent to users that you're collecting. So one thing that TikTok was doing was collecting clipboard data. So data that someone had copied to their clipboard on their phone. TikTok, the app was actually collecting some of that data without disclosing that up front. And that's something that the FTC as well is frequently paying attention to is your privacy policy disclosing all things that are both apparent and not apparent, because those not apparent data collection practices are going to be, those are the things that really need to be clear to consumers. In addition, one thing that the settlement agreement highlighted was the need for TikTok to disclose where data is being stored outside of the US. This was a big piece of the class action complaint. Most privacy policies, I would say it's really common to see these disclosures, but it's important if you are storing data outside of the US, and this is part of the data mapping exercises, which vendors have the data, where are they located? In the past, right, we do that a lot with GDPR because there's transfer restrictions under GDPR. But it's also important for compliance with US privacy laws, for telling consumers in our notice, are we storing your data outside of the US? Because that's something that they need to be informed about. In addition, yeah, the fourth one, I kind of already talked about that, to the extent there's anything being collected that is disclosed, that it's not a surprise, that, if you're operating a mobile app, ensure that it's clear that things like contacts will be disclosed, if pictures or videos will be uploaded into the app, any type of data that's being collected automatically from a phone or device, that needs to be clear. And then the settlement also required additional training. So yeah, just a few quick lessons learned. I think that we kind of walked through all of those. And then finally, I just wanted to flag the focus on children's data. This isn't applicable to all businesses, especially B2B, but to the extent that you might fall within the scope of collecting data from children under the age of 13, this is a red hot enforcement area right now. The FTC has always been really focused on COP enforcement. There's also a heightened focus on ed tech companies currently. There's been some really big recent penalties issued. I've included on the slides one with Weight Watchers and one with Recolor. Essentially, anytime that you're collecting children's data, and you're operating a child-directed website or online service, you need to make sure that the right disclosures are in your privacy notice, that you're getting the right parental consent. And something else that's also we've seen a lot of activity is with the Children's Advertising Review Unit. They're not a regulatory body. They're kind of an industry watchdog, but we are seeing a lot of activity from CARU going out and essentially identifying COPPA violations or alleged COPPA violations in different websites, apps, and generating a lot of publicity around what they're finding with different companies. So it's really important. I always suggest anytime you're doing a privacy notice update, just always be paying attention to the children's data. Obviously, there's going to be extra requirements for children under the new privacy laws, but just remembering anytime we're doing anything that could be child directed, or we might be receiving children's data, that's something we really need to focus on, because regulatory enforcement has stepped up in that area. Great. Any questions?
Okay, so this was a session on privacy notices. And so it's a high level question, but I want to give some context around it. Let's say we're dealing with a global company that is operating multiple jurisdictions. What is your current sort of guidance or approach around drafting that physical privacy notice to comply with all of those jurisdictions? That's the question. Let me give you the context to tell you where I'm coming from, because I'm really wrestling with this. So before CalOPA, for those of us who've been in this space much longer than that, there was the FTC that had a lot of enforcement actions, and in the settlement agreements, there was often requirements on how to draft privacy notices. There was guidance put out. There was guidance on privacy generators. So those of us who've been drafting privacy notices a long time had a certain way of doing it. In California, we really upended that, which you GDPR to a certain extent, but we really tried to take a global approach as much as you could, rather than have, some different sections that were very jurisdiction specific. But because California was so restricted, as you pointed out, and we started having little charts, it really changed the natural way that, I guess, the agreed upon approach of how a privacy notice should be, or was most simply structured. So this comes back to the question. I mean, after CCPA, I just saw a lot of companies go back to those jurisdiction sections, moving away from a global privacy kind of standard and trying to find all the common elements and just call out small, outliers, because California is such a huge outlier. But to draft your whole notice based on the requirements of California, which is so specific, it uses language that is so different. How are you, advising companies that have so many jurisdictions that comply with?
Yeah, that's a great question. So for the webinar team. The question was how should we be drafting privacy policies when there's requirements from Europe, from California, from now all these additional states? What's the best kind of formatting way to do that? And I think I can tell you there's different approaches out there. I can tell you what I prefer and why I prefer it. I totally understand the desire to have one privacy policy that covers every single jurisdiction, but I think the reality at this time is that's nearly impossible. There's conflicting, while there's a lot of overlap between global privacy laws, there are conflicting notice requirements. So specific language that may be required by the CPRA may not be the same as what's required by Europe and the GDPR. So there's also a question as to whether a lot of businesses will often tailor their rights, the consumer rights that they're providing to individuals based on jurisdiction. So there's a requirement under all of these laws to disclose the rights that consumers have. So when it's really common for businesses to have different compliance mechanisms for responding to rights for people from California, because that might be a little bit different than Europe, where the exceptions are different, the actual rights are different. So I think having different jurisdictional sections can help address some of those inconsistencies. Also, for example, in California, right, there's really specific requirements around, like, you have to disclose the methods for how you will submit requests. And that may not be how you want to handle requests from Europe, because that could be really complicated. So for that reason, I typically advise having separate sections for different jurisdictions where it's necessary. And one other point that I think is a benefit from that is also to the extent, if anyone's ever auditing the company or looking at the company's compliance, right? Whether it's maybe a customer wants to come in and see, oh, is this company complying with these laws? Having specific jurisdictions highlighted can help just flag to anyone in the public, right, that we are, addressing this law, we are addressing this law, so we are addressing GDPR, we are addressing CCPA. So that can be one tool for helping kind of flag to anyone who's reading privacy policy, okay, we are addressing these laws, which can be a benefit, I think, for demonstrating compliance in a public manner.
And I would add to that once you state what you're doing in a public fashion, you are now bound by that, because through the FTC and Section 5, the requirement that this is now, if you don't comply with your own privacy policy, then you're committing a deceptive act to the consumer. And so if you post a privacy policy that covers a lot more than you're required to cover, then you're subjecting yourself to a lot more liability than you're required to. I think we're about out of time. I was going to say that we have some questions online. Maybe we can answer those and post them with the video.
Yeah, and I think actually some of the questions, if you've asked one online, we'll get into some of these in the next session, which is on consumer rights. So yeah, we'll go ahead and wrap this one up. Thank you, everyone.
Thank you.
So why don't we take a 10-minute break, let them stretch their legs,